What do I have to show in that subpoena to get those phone records of a sitting? Did I mention it was a sitting United States Senator? I can't remember. What do I have to show to get the phone records of a sitting United States Senator?
Yes, Senator, there were actually 8 sitting United States
Yeah, I
Senator,
heard that.
and you would have to have cause.
I'm sorry, what do I have to show?
You would have to have cause to get the subpoena.
Good cause or probable cause?
Probable cause.
Okay.
What you just heard was not drama, but the sound of disbelief clashing with bureaucracy. Senator John Kennedy wasn't just cracking jokes. He was bringing up the alarming possibility that the Department of Justice is spying on sitting U.S. senators, and no one seems to know why.
We frequently, in criminal enterprises, subpoena cell
by
phones.
the sitting United States Senator?
Senator, they would have to have believed you were part of a criminal conspiracy, is my understanding.
Would a judge have to sign off on it? On the subpoena?
Yes, Senator. Well, for a subpoena ducus tecum, Jack Smith probably took it straight to the judge.
Now, the phone companies, particularly their general counsel, if they're worried about civil liability, even with a subpoena to get the phone records of a sitting United States Senator. Did I mention it was a sitting United States Senator?
Yes, Senator.
The general counsel for that phone company, let's say AT&T, they have the right to seek to quash that subpoena, don't they?
Phone companies frequently do that.
Yeah. And a smart general counsel for that phone company is going to call the sitting United States Senator and say, would you like to weigh in on this? Would you like me to quash the subpoena? We're talking about invading someone's privacy here by a sitting United States Senator. Could the general counsel for the phone company do that?
Well, Senator, if they believe that a crime could have been committed, they could not tip off the person who committed the crime. Again, I can't comment on details of this particular case.
I'm just asking you theoretically.
I've never seen you commit a crime, Senator Kennedy.
But let's suppose, okay, they didn't want to tip off the sitting United States Senator. But the phone company and the general counsel for the phone company, or companies, if there were more than one involved, could say, you know, this is serious as an aneurysm. This is serious as 4 heart attacks and a stroke. This is a sitting United States Senator. So general counsel would likely advise the CEO, well, you need to file a motion to quash. The telephone companies could have contested those subpoenas, could they not?
Hypothetically, yes. I can't talk about the facts of this particular case.
We're talking hypothetical.
Senator, subpoenas are issued all the time through phone companies working with the general counsel.
But they can file a motion to quash.
They could, yes.
Yeah.
In any case.
And if they should have filed a motion to quash, and a reasonable person would have filed a motion to quash, because this is a sitting United States Senator, and they didn't file a motion to quash, they would incur civil liability, wouldn't they?
Senator, typically phone companies follow a subpoena from a United States attorney.
I know they do, but they don't have to.
They could challenge it, Senator.
Yeah. And if they don't challenge it, they better have a damn good reason. Right? Right?
Senator, I can't talk about the facts of this particular case.
This is just a hypothetical.
In general, hypothetically, Senator, maybe they didn't recognize any of the names of the 8 sitting United States senators.
Hypothetically.
That was a joke.
Or maybe they should have gone to Amazon and buy some testicles online. Instead of just saying, sure, I'll just show you the phone records of a sitting United States Senator on the basis of an administrative subpoena. Now, do you have copies of the subpoena applications for
Yes,
these
Senator,
8
Senator, I can't discuss anything regarding
You
this
can't
case
even
with
tell me if you have copies?
I can't discuss any of this
All right,
with
when are
I'm
you
sorry.
going to, General, when are you going to be able to discuss it?
I can't discuss whether there is or is not a pending investigation,
I understand,
Senator.
but
This was
let's
just
assume
brought to light
if
by
there is a
Director
pending
Patel.
investigation, I don't want this to get swept under the rug, okay? Because I think you're going to get pushback from all quarters. I think the
What happened in that interaction was more than just a heated Senate debate. It was a clash between two ideas of government. On one side, Senator John Kennedy uses fury, disbelief, and black humor to reveal what he sees as a developing authoritarianism within America's legal system. On the other side, Attorney General Pam Bondi is using the traditional cloak of, "I can't comment on ongoing investigations." At first appearance, it appears to be yet another politicized show. However, the repercussions extend far beyond party lines. Kennedy's questioning gets to the heart of a principle older than the Republic itself. No branch of government should have unrestrained power over another. If the Department of Justice truly subpoenaed many sitting senators' private phone records, this is more than simply an internal scandal. It's a constitutional catastrophe in slow motion. Bondi's obsession on process is not without justification. When there is suspicion of a criminal conspiracy, the DOJ has subpoena processes in place. However, Kennedy's hypothetical was not about paperwork, but rather about precedent. When the legal system sees lawmakers as suspects, with no clear reason or judicial scrutiny, the line between oversight and excess becomes blurred. Accountability might fade in the midst of this muddle. The Attorney General's constant deferrals, "I can't discuss that," pending litigation, personnel matters, are familiar to anybody who has watched a decade of Washington hearings. They are legal cautionary statements, but they also reflect institutional tiredness. Officials fear saying something incorrect or classified, so they say nothing at all. However, when the nation's top prosecutor refuses to address fundamental concerns about the surveillance of elected leaders, silence becomes corrosive rather than prudent. Kennedy understands this. His sarcasm is more than just entertainment. It's a rhetorical weapon. By exaggerating, "buy some testicles online," he highlights the ridiculousness of bureaucratic paralysis in the face of potential constitutional violations. He positions himself as the everyday senator wanting straightforward answers, while the DOJ hides behind legalese. The act may be theatrical, but the undercurrent is deadly serious. Who watches the watchers when they themselves are being watched? The exchange also highlights a deeper issue, the normalization of secrecy in American governance. National security exclusions, sealed warrants, and presidential privilege have increased dramatically during the last 2 decades. Terrorism, espionage, and cybercrime are all justifiable by need, but when combined, they create an opaque culture. What began as emergency tools has evolved into habitual control mechanisms. When surveillance authority goes to the legislative branch, it undermines the checks and balances that keep democracy running. Bondi's responses exemplify the institutional inertia that arises when power becomes accustomed to opacity. Her cool, lawyerly demeanor contrasts sharply with Kennedy's outrage. She doesn't argue that the DOJ did nothing wrong. She claims that she can't say anything at all. It's the ideal bureaucratic paradox. Accountability is governed by its own rules. However, Kennedy's fury resonates because it reflects a broader national concern. Americans across the political spectrum increasingly suspect that the norms of accountability vary depending on who asks the questions. When whistleblowers, journalists, or politicians get too near to powerful institutions, the information gets classified or under review. As a result, suspicion feeds back into itself. Citizens lose faith in justice, and justice, feeling distrusted, shrinks more into secret. Beyond politics, there is an ethical dimension that rarely receives attention: surveillance as a moral act. Obtaining someone's information, phone records, emails, messages, is more than just a legal technique. It is an encroachment into the area where private thought meets public choice. When an intrusion targets elected officials, the risk increases. It has the potential to silence criticism, alter alliances, and weaponize knowledge.